The opposition leader. Leader of the opposition.
Thank you, Mr Deputy President. I lead for the opposition on the Serious Crime Prevention Orders Bill 2016 and the Criminal Legislation Amendment Organised Crime and Public Safety Bill 2016, which are being debated as cognate bills in this chamber. Mr Deputy President, the New South Wales Labor Opposition does not support these bills in their current form. We have serious concerns about the need for them, about the bona fides of the government and how it has embarked upon this exercise, about the far-reaching nature of the provisions and about the lack of safeguards to protect the public and to ensure the integrity and rigour of decisions that will be made under these two enactments. There was no effort by the government to secure the support of the opposition before proceeding to introduce the legislation now before the House. In developing the bills, it's now clear beyond argument, given the controversy canvassed in the debate in the other place, that the Ministry made no effort, took no steps to consult with any of the expert bodies with knowledge and insight into this area of law and policy outside of government. However, as befits a responsible opposition, a responsible alternative government of this state, we will engage with the serious public policy matters dealt with in the legislation and put forward sensible, carefully considered amendments that meet those concerns. The question is whether this government has the maturity, the good sense, to take a bipartisan approach to the very serious issue of combating organised crime. Incredibly, this legislation proposes not one but two new systems of orders: the Serious Crime Prevention Orders and the Public Safety Orders to be issued by police. This will be in addition to orders already able to be made under other New South Wales and Commonwealth criminal laws, as well as the anti-consorting laws put in place by the O'Farrell government. New South Wales Labor is resolutely in support of laws to combat serious and organised crime. We have no difficulty with giving law enforcement agencies, the police and the Crime Commission, the resources and the laws they need to protect the community from the scourge of criminal activity. It was a Labor government, after all, that created the New South Wales Crime Commission. Since the 1980s, New South Wales has had two criminal asset confiscation laws, one civil-based, now the Criminal Assets Recovery Act, 1990, and the other conviction-based, the Confiscation of Proceeds of Crime Act 1989. The process of constructing laws of this nature was commenced by the Labor government with the Crimes Confiscation of Profits Act 1985. In 2006, Section 93 T was put into the Crimes Act by a Labor government, making it an offence for a person to participate in a criminal group. These provisions were overhauled in 2012, introducing new offences which Labor did not oppose. In 2009, the New South Wales Labor government introduced the Crimes Criminal Organisations Control Act 2009 to meet the challenge posed for law enforcement bodies of bodies such as outlaw motorcycle gangs. After the High Court invalidated that legislation in Waynahu versus New South Wales, Labor did not obstruct the efforts of the O'Farrell government to enact the Crimes Criminal Organisations Control Act and the further amendments made in 2013. We understand, however, this legislation has not been used by the present government, despite the hoopla and the urgency that surrounded the overhaul of the legislation. In 2012, Labor also did not oppose the government in modernising the consorting offence in the Crimes Act, making it an offence to habitually consort with at least two convicted offenders having been given an official warning. There are preventative detention powers under the Terrorism Police Powers Act 2002, banning powers under the Major Events Act 2009, move-on powers under Part 14 of the Law Enforcement Powers and Responsibility Act, all of which were Labor initiatives. And of course, there are control order powers in relation to terrorism under Division 104 of the Criminal Code Act 1995 Commonwealth. But Labor's support for strong measures has never been blind or without regard to full concern about the proper principles that must underpin the system of criminal justice. Not because we have any sympathy for criminals, but because we know that any system is fallible and sometimes law enforcement makes mistakes, is overzealous, and the rules exist to protect ordinary citizens from the mistakes or excesses of the police and other law enforcement agencies. One obvious point is to note that in our criminal justice system, the DPP is an independent statutory officer who is able to bring fresh eyes to the material gathered by criminal investigators and is able to evaluate the capability and the desirability of pursuing a criminal action. That office holder is not caught up by the enthusiasm of law enforcement agencies whose task it is to apprehend criminals and collect the evidence against them. Another point to note is that the courts, the independent third arm of our government, are able to scrutinise and evaluate the court actions brought by law enforcement agencies. This provides both rigour and integrity to the justice system. This legislation throws out that separation of roles, that well-established architecture of our system of justice, for no good reason. The legislation is extreme, in our view, in its present form, and goes well beyond comparable legislation in Britain in terms of serious crime prevention orders. There are also fewer safeguards in the New South Wales Bill than exist in the UK legislation. The regime of public safety orders contained in the second bill, in Schedule 5, establishes something like a rival to the criminal justice system. If enacted in its present form, this legislation would allow police to avoid the courts, if they choose to, and the difficulties associated with criminal trials, and to pursue open-ended rolling orders controlling the actions of individuals or classes of persons. In their current form, the bills are likely to contravene the prohibition on arbitrary arrest and detention in Article 9.1 and the right to a fair trial in Article 14.1 of the International Covenant on Civil and Political Rights. The legislation also infringes the rights to freedom of movement, expression, communication, assembly and association, contrary to Articles 9, 12, 17, 19 and 21 of the same instrument. There's been no consultation with legal professional bodies, community groups or law reform agencies prior to the government embarking on these bills. I note the Law Society of New South Wales and the New South Wales Bar Association offer the observation that the legislation may well infringe the rule laid down by the High Court in Cable versus DPP in that it represents a contradiction to the fundamental aspects of judicial power, and the judicial process has to be beyond the power of the Parliament to enact. The fact is that there is no evidence or case of any substance has been presented by the government as to the inadequacy of the existing laws and the criminal justice system in dealing with the issues to which the legislation is aimed. Lots of assertion. No doubt this legislation would be very useful for law enforcement agencies, but whether it's necessary is a different matter. The New South Wales Bar Association, the New South Wales Law Society, the New South Wales chapter of the International Commission of Jurists and many other relevant organisations were not consulted by government and are strongly opposed to the bills. One member of this chamber has said they've received a communication from the Police Association about the bills. Well, I don't believe the New South Wales Opposition has received any communication from the Police Association. And in my brief conversation with them, they didn't indicate, well, they said they hadn't been consulted about the legislation and didn't seem particularly fussed one way or another whether the legislation was enacted. Now, I don't seek to verbal the association, but usually when that body wants something, they're not backwards in coming forwards to either side of politics. This legislation comes soon after this government's anti-protest laws, which in comparison, Mr Deputy President, now seems very mild. A trend exists in this government towards disproportionate and extraordinary laws that seriously erode the rule of law and the fundamentals of our system of legal rights and processes. The ability of, for example, of the public safety orders to be used to crack down on all forms of protest, non-violent advocacy and even industrial disputes is a real and present danger, notwithstanding the window dressing in the second bill said to avert that problem. There is no wonder that the government has not yet brought into force and effect its anti-protest laws, because something much more pervasive, something much more sinister is coming down the pipeline. If the government is serious about not wishing to impede non-violent protest, advocacy and industrial disputes, they should accept our amendments to put that beyond any doubt. Where Parliament determines that authorities need unusual powers to deal with serious and pervasive issues such as organised crime or terrorism, they must be subject to judicial oversight and other checks and balances to protect against error and excesses, to protect the community. And that is what our amendments will seek to do. I turn now to the details of the two bills. The Serious Crime Prevention Orders Bill provides for the making of serious crime prevention orders, but it goes well beyond the comparable legislation in Britain and Scotland. There are also fewer safeguards in the New South Wales Bill than exist in the UK legislation. Here the power to seek such orders will be conferred on the Police Commissioner and the Crime Commissioner, as well as the DPP. So persons who are engaged in the front line of law enforcement, not the independent prosecutor, but, if you like, the policeman, will also be given the ability to make those applications. That doesn't happen in the UK. Under the UK model, only the independent DPP of England and Wales and of Northern Ireland and the office holders of like positions, such as the Director of Serious Fraud and the Director of Revenue and Customs, may bring such an application, which is a very important distinction. The UK model also occurs in the context of very strong domestic human rights legislation, the Human Rights Act 1998 UK, and the European Human Rights Framework, which comprises the Convention for the Protection of Human Rights and Fundamental Freedoms, and of course the European Court of Human Rights, both of which provide protection for citizens by ordinary citizens. There are no comparable protections in New South Wales or Australian law. An SCPO will be able to be issued by the Supreme Court or upon a conviction by the District Court on the application of the Crime Commissioner, the Office of the DPP or the Commissioner of Police. The Court will be able to issue the order where satisfied on the balance of probabilities that a person or business is involved in serious crime-related activity or as indicated by the District or Supreme Courts following a conviction for a serious offence. However, an SCPO will be able to be issued if a person is not charged with any criminal offence and even if they have been acquitted of a criminal offence, even if the fact situation supporting the SCPO is substantially the same as the criminal charge. In the United Kingdom, the guidelines for the Crown Prosecution Service make it clear that if there is evidence to support a criminal prosecution, that should be pursued. An SCPO should be pursued only where there's no real prospect of a criminal conviction. The proposed New South Wales model has no such protection, giving rise to a real risk that over time law enforcement will use the much easier civil process of an SCPO to pursuing often difficult criminal trials with the need to prove matters beyond reasonable doubt. This would potentially endanger public safety and would be contrary to the public interest. Dangerously, the New South Wales Bill also permits the authorities to pursue an SCPO even where a person has been acquitted of criminal charges. And as I indicated earlier, because of the prosecution guidelines, this cannot occur in the UK as a matter of administrative practice. It's not in the Serious Crimes Bill 2007, but it's in the practice of the Prosecution Service. That safeguard does not exist in this state, and that's why this legislation in its current form is so dangerous. An SCPO would include prohibitions or requirements that a court considers appropriate to prevent or disrupt involvement in a serious crime. Clause 6 provides some protections by listing things that cannot be included in an SCPO, including protection for legal professional privilege, confidential information, and of course special protections for banking businesses, which of course is similar to the UK model. Importantly, there is no clear protection against self-incrimination. There is the ability to demand things from people in writing under this legislation. And, for example, if you look at the legislation for ICAC, if you look at the legislation for the Crime Commission, in both of those cases where the issue of self-incrimination arises, a person may object to answering questions. They still have to answer, but their answers then cannot be used in any criminal trial against them. It can only be used for the purposes for which the information is sought. Now, given that these are not criminal trial processes that we're dealing with in this legislation, there should be at least equivalent protection against the risk of self-incrimination, and that is absent from the government's package. I acknowledge that interjection, but it's not true. An SCPO would last for a maximum of 5 years, and a breach would be punishable for up to 5 years imprisonment and a fine of 300 penalty units, which is $33,000 for an individual, and 1,500 penalty units, or $165,000 for a corporation. Importantly, the legislation as it stands contains no defence to these charges. In fact, in either bill, a charge under either of these bills, there is no defence. Serious offence and serious crime-related activity is defined as it is in the Criminal Assets Recovery Act. However, this legislation goes further with an additional definition of involved in serious crime-related activity, which captures not only the engaging in serious crime-related activity, but also conduct that facilitated another person engaging in such activity, and conduct that is likely to facilitate another person engaging in serious crime-related activity. In considering an application for an SCPO, a court may rely upon hearsay evidence. However, the respondent will be put on notice and served with the material. Now, it's important, the provision that deals with hearsay evidence in this legislation clearly abrogates the existing protections against the admission of hearsay evidence. Hearsay evidence can be admitted in other trials in accordance with the terms of the Evidence Act, but this abrogates those protections. And it's quite clear that the intention is to remove the hearsay rule. There's no doubt about that. I note the contribution of Mr Henskin's SC in the other place regarding hearsay evidence. As I indicated, there are a number of exceptions to the prohibition of hearsay evidence, as he points out, but they're in the Evidence Act, and they replicate the tests that evolved in the common law with some refinements and additions. This bill abrogates the rule against hearsay evidence in a most serious way without justification. I also note the contribution of that honourable member on the subject of the nature of the orders themselves. The member for Ku-ring-gai makes his observations in the context of the most extraordinary attack on the Bar Association of New South Wales, in which both he and I are members, and of its current president, Noel Hutley SC. Such an attack is not only unwarranted but unworthy of a member of this Parliament. I also note that the honourable member in the other place made a reference to the judgment of the English Court of Appeal Criminal Division in R versus Hancock's and another as authority for the proposition that such orders are, quote, not an additional or alternative form of sentence. It is not designed to punish, unquote. But perhaps he forgot the reason the court reached this view. It was not due to the terms of the legislation, but the fact it is subject to the European Convention on Human Rights. I quote from that judgment at page 540, paragraph 10, and I quote, "The necessity for orders to be proportionate also follows from the fact they will almost inevitably engage Article 8 of the European Convention for the Protection of Human Rights and Fundamental Freedoms, 1950. The legislation not only requires the orders to be made according to law, but it requires they be proportionate. See authoritative expression in E.B. Kosovo versus Secretary of State for the Home Department. It's 2008 for All England Reports 28 at paragraph 7. The legislation, the Serious Crime Act 2007 UK, only requires that an order be appropriate and be made according to law. It's the European-wide human rights framework that constrains the operation of that legislation to ensure, as the court put it, at page 541, paragraph 10, that, and I quote, the provisions of the order must be commensurate with the risk, unquote. There is no such requirement in the bill before this House. As I mentioned at the outset of my contribution, there is no human rights or other legal safeguard that will provide the same rigour and proportionality in any orders that are sought if the legislation is made in its current form. Intriguingly, there is no counterpart in the SCPO regime proposed to Clause 87 R to E, F and G, which will apply to the public safety order regime. It's there for the public safety order regime as an important safeguard, not present in the SCPOs. I'd like to know why. Looking forward to your answer. Clause 11 provides for a right of appeal to the Court of Appeal on a point of law, but a restricted appeal on facts. As it would be an appeal from a discretionary decision, the scope of such appeal rights are of course very narrow. An applicant has to establish that the judge made an error in the exercise of his or her discretion in accordance with the rule laid down in House versus King, which is a very narrow and difficult appeal right. The criminal legislation, and of course, where a company is convicted of breaching an order, an application may be made to the Supreme Court to wind up the company if the applicant considers it's in the public interest to do so. The Supreme Court make an order to wind up a company where the company has been convicted and it's just negligent to do so. We have no objections to that. The Criminal Legislation Amendment Organised Crime and Public Safety Bill 2016 is a more sinister and serious piece of work. It amends a number of other acts. The opposition is concerned only with Schedule 5, which makes amendments to the Law Enforcement's Powers and Responsibility Act 2002, New South Wales. The amendments to LEPRA will permit a senior police officer defined as the rank of inspector or above, and I note that an inspector is, I think, the lowest rank of commissioned officer, police officer in New South Wales, to issue a public safety order preventing a person from attending a place or event for a limited period if the officer is satisfied they would pose a serious risk to public safety or security. They are lifted from the equivalent South Australian laws, the Serious and Organised Crime Control Act 2008, Part 4, Section 23, but without the safeguards found in that legislation. While the SCPO requires someone to have engaged in serious criminal activity, there's a very low threshold for a person to be made subject to a PSA. Only the satisfaction of the relevant officer that a person's presence at a particular location and time would pose a serious risk to public safety or security. But this is widely defined to cover everything from property damage to the serious injury or death of a person, so a very wide scope, a very low threshold. And of course, when dealing with what it takes to satisfy an officer, if we have a look at the High Court decision in George versus Rocket in 1990, it's quite clear that, and I quote, the assent of belief is given on more slender evidence than proof, quote unquote. So it's a very, very low threshold, both as to the level of satisfaction needed for a police officer and the danger that will trigger the ability to order a PSO. A PSO can last up to 72 hours, but where an order relates to an event that occurs over a period longer than 72 hours, the order will last for the duration of the event. If an order lasts for more than 72 hours, a person can appeal, subject to it, can appeal to to a single judge of the Supreme Court. If the order is for less than 72 hours, there's no capacity for any review or challenge to the order. There's no right to be heard before an order is made. And not only is there no capacity to approach the court, on the face of the legislation, there's not even the capacity for a more senior officer to review the appropriateness of the order. However, there is provision to issue multiple orders for a series of events, such as consecutive Saturday nights, which appears to provide a way to bypass the time restriction without engaging the appeal rights. In fact, there's nothing to prevent consecutive 72-hour public safety orders being placed on a person one after the other, week in, week out, indefinitely, as long as there's separate and distinct orders, and no capacity for this to be reviewed by a court or any other body. While a proposed SCPO can only apply to persons aged over 18, a PSO can apply to persons aged under 18 and to persons with an impaired intellectual functioning. And I refer, of course, to clause 87, capital T, subsection 2. This is, in the view of the Labor Opposition, a pretty low standard, even by the standards of the coalition parties. In his second reading of the speech, the Police Minister claimed there was a protection for non-violent advocacy, protest, dissent or industrial action in the legislation, found in clause 87R3 and in other places. However, the drafting makes clear that such a protection rests on a police officer's belief that these are likely to be the primary purpose of a person's presence at a particular location. If the officer believes otherwise, that the primary purpose is for a different purpose, an order may still be made in accordance with 87 capital R, endangering the capability of other law-abiding citizens to conduct the non-violent protest, advocacy or indeed industrial disputes. I note the excellent and high-quality submissions made by the New South Wales Law Society, the Society of Labour Lawyers, the Council for Civil Liberties and, of course, that radical left-wing outfit. I make the point, I use the term sarcastically, the New South Wales Bar Association. I'd urge all honourable members to read and reflect on the contents of those submissions, which I will not read from because I note honourable members in the debate in the other place did so at great length. There is insufficient time here to do justice to their arguments and the material they provide, but it should give this House pause for thought. Yes, let's give the New South Wales Crime Commission and the police the tools to combat serious and organised crime, but let's do so with proper safeguards. And I note, because I serve on the Parliamentary Oversight Committee for the New South Wales Crime Commission, among other bodies, and it's quite clear that what we see here in the bill is not what was originally conceived of in terms of public safety orders. The safeguards that they should contain, that in fact they do contain in the overseas counterpart, are absent here. So something clearly has been lost in the translation in terms of the serious crime prevention orders. In particular, the New South Wales Bar Association is of the view the bill confers very broad and far-reaching powers on the police and creates a real danger of arbitrary and excessive interference with the liberty and freedoms of persons in the state for a number of reasons, some of which I have outlined, and I'll just touch on some of the ones that I haven't yet outlined. Because there's no applicant for a PSO, there is no testing of or contradiction of the material relied upon by the senior police officer in making a PSO, and there's no opportunity for the person to be heard. Of course, a PSO may be related in relation to children and persons with impaired intellectual functioning. The bill is silent as to what might constitute a class of persons for the purpose of the power to make a PSO. The concept of an area to which a PSO can apply is also not defined and is unconfined. In relation to a long duration PSO, there is no upper limit on the duration of the order. In many cases, the person, the subject of an order, will have no means of knowing the basis upon which the senior police officer has reached the satisfaction required by 87 capital R. While there is a right of appeal to the Supreme Court in relation to a PSO, which is not a lot, but as I indicated, that's a fairly illusory right because almost no PSOs longer than 72 hours will be made. There's a range of other observations that could be made, which are in the Bar Association submission, but also a submission which honourable members should familiarise themselves with. The Supreme, but one point is common to the legal expert bodies, and that is the constitutional validity of aspects of the bills must be regarded as doubtful. This is because the Supreme Court is required to stand in the shoes of the original decision maker, a senior police officer, in the case of a PSO, and make what the court considers to be the correct and preferable decision. That is a non-judicial function that is substantially incompatible with the functions of the Supreme Court of a state. This brings to mind not only the reasoning of the High Court in Cable, but also in the judgment striking down the original New South Wales anti-bikie legislation in Waynahu. In this bill, the Supreme Court is enlisted in implementing the decisions of the Executive in proceedings in which there is an inherent lack of fairness between the parties and in which the Commissioner retains a level of control. And I note that while the Police Minister seeks to assure the Parliament that there's no problems with the constitutional validity of the proposals, he doesn't set out any basis upon which we might derive that comfort, given the very cogent reasoning provided by the New South Wales Bar Association. There must be real doubt about the validity of the proposed power to make public safety orders in its applications to individuals or groups that are exercising their implied constitutional freedom of communication about government and political matters, notwithstanding the content and operation of proposed Section 87R(3)(a). These observations are also made by the Bar and other bodies in relation to the proposed serious crime prevention order regime. Now, I won't touch on the other aspects of the legislation about which we don't have any difficulties. I'll now address the reply speech given in the other place by the parliamentary author of the bills, the Deputy Premier and Minister for Justice and Police, Mr Troy Grant MP. While acknowledging the concerns that have been raised about whether there are sufficient safeguards in the bills, he says, quote, "The Attorney-General's contribution should go a significant way in allaying concerns," unquote. Sadly, having read the Honourable Attorney's contribution, the reverse is the case. This is a very sad Attorney-General. It gives me no pleasure to say, but she doesn't have the confidence of either the legal profession or of the judiciary, and the contribution she made in this debate in the other place may disclose why this is so. The contribution signally fails to address the serious shortcomings in the legislation outlined by the expert legal bodies or in the debate in the other place. Furthermore, her office has been fundamentally compromised by being subsumed into the Justice Department. In all previous governments, new law enforcement measures would be subject to the scrutiny of an alternate and expert agency. The creative tension at the very heart of all previous government policy on law and justice, whether we are discussing police measures being critiqued by the former Attorney-General's Department or new law reform measures being challenged by the police force and the police ministry, that creative tension is now gone. And the Attorney is the junior minister in the agency, which may explain a lot of the content of the bills and the lack of safeguards. Returning to the reply speech of the Deputy Premier, is critical of my colleague, the member for Charlestown and the other place, for her contribution and her request for examples of where the orders proposed in the bills are necessary. And he indicated that his office has supplied myself and my colleague Guy Zangari, MP, Shadow Minister for Justice and Police, with those details when we briefed them. Now, I had perhaps foolishly thought that the information supplied in the context of that briefing was confidential, and we respected that confidence. But apparently, according to the Deputy Premier, there was no confidentiality. In which case, I'm happy to inform this House that the examples given in connection with the public safety orders were entirely hypothetical. We had asked for some real-life, even if anonymised, examples of where the authorities believed that PSOs were necessary. What we were provided with were only hypothetical examples of where they may be able to be used. No information was supplied to us as to why in those hypothetical examples existing legal mechanisms available to the police or to the Crime Commission were not able to address the situation. In connection with the SCPO regime, 3 examples were provided, apparently from real life, and for that reason I will not outline the fact situations. But again, on the face of them, there was no information supplied as to why the existing law could not deal with those situations. I accept that these bills would make the task of the police and of the Crime Commission a lot easier. But as I indicated earlier, that's very different to saying they are actually necessary. The government has not discharged the burden on it of showing to the Parliament why this is necessary. The government has not provided any substantial basis for the measures contained in these bills, other than that they would increase the powers available to the authorities. In a democratic society, that should not be a sufficient basis for sweeping new law enforcement powers, particularly ones with grossly inadequate safeguards and, in our view, no real supervision by the independent courts of our state. Now, I know SCPOs will be made by the courts, but the basis upon which they may do so is not sufficiently protective of the rights of individual citizens. This was strongly reinforced by the briefing we received from officials from the Justice Department. Despite our requests, they, the subject matter experts employed in the key government department responsible, could not offer us any practical or policy rationale for the measures in the bills, the only reason being advanced by the government, not by the public servants, but by the government, is that this was an election commitment made by the government at the 2015 election. And I note that in his extraordinary attack on the New South Wales Bar Association, the Deputy Premier stated that the Bar had taken no interest in the policy since it was announced in March 2015. That announcement, a press release on 3 March, outlines the policy aspects now contained in each bill, but fails to provide key details. No definition was provided of what would constitute serious crime-related activity, who a senior police officer would be, or on what basis a PSO would be able to be issued, nor was the fact that there would be, at least in the case of a PSO, no scrutiny provided by an independent prosecutor or the courts, or that in relation to an SCPO, the legal safeguards present in the UK and Scottish versions would be absent. Let's be clear. The announcement of a policy direction in a press release is one thing, but the details of legislation is quite another. It's not unreasonable that the expert legal bodies, the Bar and the Law Society, would wish to be consulted on the details of such changes to the law. And I note the attack on the Bar by Mr Henskins SC for not consulting with the government on the matter. As the Bar of the President of the Bar, Mr Hartley SC, noted that the Association had written to the government on 13 April and had received no response. In the letter from the Bar to the government on 2 May, attaching its submission on the public safety orders regime, that organisation again outlined its willingness to sit down and discuss with the government its views and the reasons for them. So I asked the Honourable Parliamentary Secretary, has your government formally responded to either communication from the Bar Association or any other organisation that has made submissions on these bills, and have you met with them? Finally, the Deputy Premier says we should take comfort from the fact that although not binding, not actually in the legislation and not actually legally binding in the state of New South Wales, the counterpart legislation has been interpreted by the UK courts such that, and I quote, a serious crime prevention order must address a real risk of future offending behaviour. It must be proportionate and commensurate with that risk, unquote. But he completely fails to mention, and perhaps he fails to understand, that this is not because of the terms of the UK law, but because of the presence of both domestic and European human rights laws. The absence from this state of any such human rights framework means that a similar approach to interpreting the laws before this House would most likely not be open to the courts here. I wonder whether those opposite, or even the responsible minister, have a real appreciation of what they're actually asking Parliament to enact here. I acknowledge that interjection. The minister states that we should, and I quote, be satisfied that this legislation will not be abused, unquote. But he gives no basis on which we should reach this state of satisfaction. Earlier in my contribution, I outlined many powers the authorities have been granted by this Parliament, but which appear to not have been used. I referred also to the new consorting laws in Section 93 capital X provisions that the government has introduced. Now, they have been used. The first person charged was a young man with an intellectual disability, and the Ombudsman has since revealed numerous instances where the powers used were used specifically in a way the government promised they would not be. This gives no confidence that these laws, if passed, will operate fairly, properly, or as intended. The Minister also states, and I quote, the New South Wales Government is also confident that the legislation will withstand any constitutional challenge, unquote. Beyond this bare assertion, he provides no basis upon which this Parliament can be confident that the real constitutional concerns raised by the Bar, among others, is addressed in the legislation. As I indicated earlier in my contribution, the Labor Opposition will put forward sensible and carefully considered and responsible amendments that meet each of the criticisms I have outlined to the package of bills before the House. Labor's amendments will ensure only the Director of Public Prosecutions can apply for a serious crime prevention order. They will narrow the basis upon which an SCPO can be sought and ensure that there is a common approach taken for public safety orders. Just pausing there, we think it's ridiculous the government is asking the Parliament to enact 2 regimes of orders. There should be 1 regime of orders, if any. And if you're going to have 2 regimes, they should be synchronised by requiring a similar trigger. They should have the same risk trigger, not 2 wildly divergent risk triggers. And in fact, if you're a cynical person, you'd actually draw the conclusion that the government's presenting these 2 bills, one with the veneer of court approval and due process, the SCPO bill, and the other, the more sinister, more pervasive one, the public safety orders regime, which they hope no one would notice because it's not actually up front or centre, it's the last schedule in the second bill dealing substantially with an overhaul of the criminal assets confiscation regime. Sneak some new police powers in. They just didn't want to have a frank public debate about the merits of the matter. So we think there should be a common risk trigger for both regimes. Our amendments will also seek to remove the capacity to seek an SCPO if a person has been acquitted of a serious criminal charge if the subject matter is substantially the same. We think that in the current form it smacks of having two bites of the cherry, that you can't, if the authorities cannot achieve a criminal prosecution against someone, they will proceed against them in a second way. Well, I acknowledge that interjection. The authorities should make a choice as to whether they wish to take a preventative approach or if they have the evidence to seek a criminal prosecution. There is something, I think, sinister and untoward having, if you like, two bites of the cherry. Our amendments will also specify that only the Supreme Court may issue serious crime prevention orders with, of course, repeal rights. We also seek to ensure the capacity of the Supreme Court to admit hearsay evidence is the same as in any other legal proceeding, but not greater. Our amendments will also seek to remove Schedule 5 from the Organised Crime and Public Safety Bill that would allow a senior police officer to issue public safety orders. And we want to ensure that the protection against self-incrimination is not infringed. If the removal of Schedule 5 is not accepted by this House, the opposition will also propose further amendments to ensure that only the Police Commissioner or a Deputy or Assistant Police Commissioner may make a public safety order. Although the term senior police officer is used in the regime, the fact we don't think the police officer specified or class specified is senior enough. As I indicated, I think the rank of inspector is the lowest rank of commissioned police officer. If such powerful orders are to be available to a police officer to be made without court approval, without any court oversight, without the ability, well, I know prohibiting court oversight, but without the ability to have an independent judicial officer scrutinise and evaluate whether that order is proper and appropriate, in fact has even been lawfully made, we think the rank at which the police officer who can make that order should be seriously elevated. We also propose an amendment or amendments that will ensure that an order is only able to be made if there's a serious risk that a person or persons will engage in or cause serious crime-related activity, as will be the case in the SCPO regime. At the moment, that risk to public security covers everything from property damage, although at a serious level, through to serious injury or death. We think serious crime-related activity should be the common trigger. We also think, however, the current definition of serious crime-related activity in the SCPO bill is far too broad, because it doesn't just cover people who are or have engaged in it or are likely to engage in it, but as I indicated earlier, it covers people who, whether knowingly or not, and I think that's a big problem, have or may facilitate someone else engaging in serious crime-related activity, or that they are likely to do so. The triggers are just too low, and the connection between a person and the behaviour that can be caught by the orders is just too tenuous. We think there should be an adequate right to be heard before any public safety order is made, and we think there should be a proper appeal rights against the making of any order. And we also believe strongly that persons aged under 18 and other vulnerable persons, including the intellectually impaired, should not be subject to a PSO, so that will also be the subject of an amendment. The amendments will also be directed to ensuring that both bills before the House are subject to the anti-discrimination legislation, and that the legislation contains proper protections for non-violent protest, advocacy and industrial action. And on that last point, we note that the Police Minister claims that the protections are in the bill, but when you look at 87R 2C and 3, it rests on a police officer's belief that those things are the primary reason for a person being in a particular location. Thank you. It's an unchallengeable, untestable assumption by the police officer. We think there should be an objective standard of protection applied so that persons who are not engaged in criminal activities of any kind may still continue to engage in lawful activities of non-violent advocacy protest, and of course in the context of industrial matters, pursuing their industrial rights. We think the risks to those persons and those activities posed in this legislation is far greater than the government's recent anti-protest laws, and that may well be the reason why those laws have not yet been brought into force and effect, because a much more effective tool is about to be conferred upon the police. We hope the House joins with us in amending the legislation. If we do not get sufficient amendments, we will not be able to support the legislation on the third reading.